In a will, trust, power of attorney, and healthcare directives guarantees your intentions are clear, reducing the chance of disputes or confusion when you are gone. Hello, welcome to B3 Inspire, where we build our foundation, believe in our potential, and become unstoppable. I'm Betty Johnson, and today's episode is episode 9, Estate and Succession Planning, Securing Your Legacy. Now, I know that talking about will, talking about estate, and what happens after we're gone, it's not that exciting.
Not at all.
Could be scary, and it could feel really heavy, and sometimes even uncomfortable.
Mm-hmm.
But it's necessary that we discuss these things and plan ahead as part of creating that generational wealth. And joining us talk about this important topic, it's our very own financial expert, author, somebody who's lived with many years' experience in advising people around this topic, Edem. Thank you for coming back and always giving and giving and giving. We're so grateful to have you.
Thank you for having me. It's always a pleasure to be here and to share and to educate. And really, today's topic, I cannot stress how important it is. You see, life is really about learning, it's about earning, and it's about returning. Right? So
learning, earning, returning.
Exactly.
Fabulous.
And somebody says that there are 3 stages in life. There is the morning, there's the afternoon, and there's the evening.
Okay.
And even there is the night aspect of your life. So they said that between the ages of 0 and then 25, you are pretty much the morning stage of your life.
Amazing.
Whereby
all the fun happens.
You begin to learn and grow and everything happens. And then between the ages of, let's say, 25 to maybe the 40s, that's the stage whereby they call it maybe the afternoon.
Wake up
when you are maximizing opportunities.
That's right.
And then you are learning a lot and you learn a lot.
Yes.
And then from 40 and then maybe the age of maybe 60, some say 50, some say 60, depending. And say the age is just a number, but yeah, so at that particular age, they said it's the evening part of your life. And then anything above the 60 onwards, then it says the night where you begin to rest and reflect. So really, the bottom line is that at every single point in your life, there's the need for you to plan towards the last stage of your life, which is maybe the evening and the night, which is the part whereby you return. And this is what this topic is all about. It might not be as exciting maybe as investing or maybe one of the other topics, but really is so much important. But it will save you a lot of headache, a lot of heartache, and a lot of stress down the line. And in fact, I'm glad that we're covering it.
Amazing. It's that peace of mind.
Absolutely.
Whether you're alive or you're gone.
Absolutely.
Knowing that you've put those structures in place.
Absolutely.
Let's dive in. First of all, Edem, can you demystify the term estate planning? It sounds grand, like you need an estate or a mansion to be able to do it. But what does it really mean?
Yeah, let's break it down. So simply look at the 2 words, estate and planning, right? Okay, so when you think about estate, it's not really so much about land or it's not so much about having properties out there. The estate really is about everything and anything that you own, and even the things that you owe. Okay, so it's all part of the estate. So we're talking about things like, the land, obviously, the properties, obviously, your money in the bank, your investments, your cars, your retirement, your expensive jewelry, your call them something chattels, and even your expensive art, your gold. So all of those stuff comes, or we call them all of those possessions, is what is defined as your estate. So things that you own, and even the liabilities, the things that you owe. Okay, and so those are the estate. And when you think about the planning aspect of them, it's about managing the estate. So the planning aspect is about managing. So think about estate planning as really broadly, estate planning is in through two broad aspects. This is the managing and distribution. Okay. So managing of the estate, which is the planning aspect of it. So managing everything that you own and you owe whilst you are alive. Okay. And then how to transfer that on when you're no longer here. That is the distribution part.
That's the distribution.
Ensuring that it's being transferred on onto the right people according to your wishes.
That's right.
And not leaving it to the system to be able to distribute it in a way where sometimes it might not be according to your wishes, or sometimes if you not distribute according to your wishes, or there's nothing there, it could lead to all sort of issues whilst you're no longer here. So estate planning simply is about the transfer of the things that you own and then you owe, managing it whilst you're alive, and once you're no longer here, how it can be transferred and distributed according to your wishes.
Thank you for explaining that so clearly. Right, so who actually needs this?
Well, pretty much everyone really needs an aspect of estate planning. So if you have any assets or loved ones, whereby sometimes when we think about loved ones, we think about maybe the people that are biologically mine, or sometimes maybe people who are quite sort of close to me, but not so much so. Loved ones could be organizations that are dear to your heart.
That's right.
Charities out there. It could be even a party out there, or an association out there, whereby you have a level of affiliation with, that you need to put a plan in place. And the thing was that if you don't put a plan in place, all sort of things can happen. Okay? Or if you don't have a plan in place, all sort of things can happen.
Someone will plan for you.
Somebody will plan for you. The court, the system will plan for you. There might be issues while no longer here, and maybe depending, the estate might incur taxations, which you don't want. If you work hard for it, if you have it, why don't you ensure that you keep as much of it and then pass as much of it on as possible?
And it's not a case of, avoiding tax. It's a case of being efficient with your tax.
Absolutely. Being efficient with the taxation, no, at all. It's not a case of avoiding tax at all. So because the system is there for us to use when it comes to taxation, when it comes to the rules and regulations, it's there for us to use to our advantage. So ensuring that the right rules and also the right tax laws and then the right measures are employed to your advantage is really what it's about. And what is quite striking is that talking about efficiency, there are so many people out in the UK, and it's not just the UK, around the world, where they don't have things in place to help them to manage this efficiency.
That's right.
I mean, in the UK at the moment, there's more than 50% of people don't have the basic estate planning tool.
Wow.
And it's quite striking. I mean,
you would have thought that this is a developed country.
Yeah.
And therefore people are well educated, people plan, people work really hard, and therefore they will put the right structures in place. More than half, that's
more than 50% don't have anything in place. It's just, so people, the whole concept of death is far away, and nobody want to think about death. Absolutely.
I can see why, but at the same time, I would rather when I'm not here, things are in order. So it is scary and it's uncomfortable. I can see why we'll put it on the back burner.
Exactly. Nobody want to think about death. Nobody want to think that anything will happen to anybody. But as we discussed in the piece about protection,
that's right.
It's about planning for the eventuality. And then planning for things that you do not expect that if, and in this case, when it happens, it means that you've got the right structures in place to ensure that your loved ones and also your estate, the things that you own, are being protected, And also, I'm sure you don't want to pass on any liabilities to your loved ones.
That's it.
That's the reason why you love them. You want to give them gifts and not really want to give them any sort of liability. So you want to ensure that you pass on things in the proper manner.
Amazing. So, estate planning broadly covers will, potential trust, beneficiary designation, and power of attorney, either for medical or directives. Is that right?
That's right.
Right. So, we are going to break these down, but the key message here is everyone should have the basic estate planning.
Yeah.
It's not hard or expensive in many cases, and it spares you and your family that trouble. Let's start with the basics. Let's focus on will first.
Yeah.
Okay. What exactly is a will? And what should a good will include?
Good question. Yeah, basic, but a really good question, really. So let's really start from the foundation.
Okay.
So for a will to be valid, right? And then once we look at that, the whole aspect of defining a will come to light. So for a will to be valid, especially in the UK, the will, number one, very important. Sometimes seem as if it's not, or it's sort of, for a will to be valid, the will must be written.
Must be written. It cannot be in your mind.
It cannot be in your mind. You cannot put in a video. You cannot just say it that way. When I die, give everything to my family. You can't. Saying it verbally will not hold anything. So for a will to be valid, the will must be written. Okay.
Yes.
Now the will must also be done by anyone that is 18 years and above.
Okay.
Who've got capacity. So they've got sound mind.
Yes.
And that will must be signed by the person who's establishing the will.
Yes.
And then witnessed by somebody. In this case, a witness.
Yes.
And then the person that's also witnessed and has to, the person that's established will have to witness that the person that's witnessed is signing.
Yes.
Right. So once these elements comes together, then you have a document. Now that document is a will which really expresses your wish. And when you pass away, to ensure that the distribution of your estate, again that word, and again distribution, is done according to your wish.
Amazing.
So it's that legal document that makes everything happen when you're no longer here is a will. But for it to be valid and for it to be called a will, all of the elements that I spoke about must be in place, or else it will not hold any water when you go to the court.
And you did mention about witness. Are there any other key people that needs to play a role in a will writing?
So obviously, there is you, which we will call you, so the testator. Okay, who is establishing the will? So very important. Without you, there's no will. Then there is what we call the beneficiary. Of the will. So are the people that you want them to benefit from the will and your asset, your estate when you're no longer here. Then there's what we call the executor of the will. Okay, so the person or the individual or organization that will ensure that your wishes are being administered accordingly. Okay. Now
so they carry out your instructions.
Exactly. That's right. And so these individuals, so we've got the testator, we've got the beneficiary, then we've got the executor of the will, then we've got the person that will have to witness your signature. Very important. These individuals must be present, must form part of the whole structure of the will for it to for it to come to life. But also within all of that has to mean that, for example, if you leave behind a minor, Yeah, anyone be under the age of 18.
Yeah.
And there must be a guardian that is being stipulated in the will to ensure that that minor is being taken care of. Again, you don't want to leave social services to take care of your children when you're no longer here. So there's a reason why this document is very important. And also ensuring that all of your sentimental values are all stipulated in the will. Okay, some people even go as far as to ensuring what should happen with and in their funeral when they're no longer here, so that nothing is left to check. Remember, it's expressing your wishes and showing that your wishes are being done accordingly. So some people ensure every single kind of music should be played. All of that is in there, so nothing
is missed.
It's missed out.
I mean, what I'm thinking right now, like bringing my cultural background in, where I come from, where the celebration of funeral is huge. And I'm just thinking that, making it very clear for your children or your loved ones to say, this is where I want to be buried. This is how I want my funeral to be done. Because maybe you might not want your children to go under the pressure of family insisting that bring the body to Africa or all of this, that do happens and causes so much stress. So if you've got that clearly indicated, it saves everyone the hassle.
Yeah, absolutely hassle. So I remember let me put it generally out there. So if, for example, you were not born in the UK and you got family abroad, or the fact that even sometimes you're born in the UK but maybe you've got a background in, I don't know, in Asia or in Africa or wherever, and then because you got family there and you've been there but born in the UK, you went there, you loved it so much, and you've got some affiliation out there, you say that, you know what, when I die, I don't want my body to be buried in the UK because I've got huge family back home in Portugal and Turkey. So make sure that when I die, my body is sent out there. Here's the thing: if you send it to someone and that person is not present to let everybody else know that is what you wished and it's not in the document, it will not happen. And even if you told that person and that person is there, and let's say that person is not even part of the family but maybe a friend, if that person told your family that, again, I remember when he was alive or she was alive, so this is what wanted to happen, would they really believe you? But if it's in the document, it's there. So you there's some of these things that as you have wished, let it be so.
There was a recent misconception I was corrected by a very good friend, lawyer of mine. I never thought that as an executor, you can also be a beneficiary of the will.
Yeah.
And I don't know why I had that misconception. I don't know whether people also think the same, but it was just pretty much recently that I found out that your beneficiaries could also be executor to your will.
Absolutely. Yeah.
Is that not conflicting though?
Well, not necessarily, because what tends to happen is that, remember that the executor is different from the testator of the will. So because the testator of the will is the one that is the owner or the estate, and the person that really ensures that his or her wishes is done, he or she can pretty much determine who should benefit or should not benefit. And as long as it's there and he or she has signed and the signature has been witnessed to say that this is my wishes, is in the court of law and in the eyes of the law, it cannot in any way be rescinded. It must be honored. So if the beneficiary that says, I want this person to benefit by saying, again, it's executor, hey, that's what he wants.
So what happens, Edem, if you die without a will? That's interstate. What happens?
Good question. Another good question. Simple, but it does happen. And please, you don't want that to happen. Not in the slightest chance, because number one, I've dealt with cases and the pressure and the stress that is left on the family who's already grieving, and they have to carry upon themselves to go through if there is no will, it has to go through the probate, and when you go through probate, now what would happen is that the system or the court system, the law system or court of law would then determine what should happen to your estate.
Wow.
So any wishes that you had in your heart or in your mind that was not documented, it goes out of the window, or it goes down with you. And then now it's left to the system or the state to determine what should happen to your estate. Do you want that really to happen?
That's scary.
I guess you don't want that to happen. I mean, pretty much anything that you've left behind, right? I mean, the system will just determine what should happen. So it's called intestacy. Intestacy if you die without a will. So normally, if you leave behind a partner, if you leave behind a wife, a husband, or civil partner, it means that they will be priority, and then also your children as well. But normally, it will be the partner or the wife or the husband, in this case the spouse. They will take priority. Then there'll be the children that will follow on next. In this case, if for example there's no partner, then the children will. Then if there's no children, it goes to the parents. Any living or surviving parents. If there's no living or surviving parents, then it goes to the siblings.
Okay.
If there's no siblings, then it goes to the uncles and the aunties.
Okay.
Then if there is no uncles or aunties, then we come to the cousins.
Wow.
Yeah, and so for down the line, so they can actually trace any surviving relative or bloodline person within the family line. So it goes in such order. But if, for example, the first priority, which is the partner or the spouse, is alive, when I say partner, civil partner, according to law. So if there is a survivor one, it stops there. It doesn't go down. It doesn't go down the chain.
Okay.
It's only if one of those is not alive, then it goes. Then they look for the next person on the hierarchy, the next person down the hierarchy, and then the next person according the hierarchy, as I said before. And that's what intestacy is. And the process can take up to 6 to 12 months, and even sometimes more, before anything can be passed on or distributed to the family. I mean, if, for example, there's anything in there that, for example, financial sort of benefits, and these financial benefits could be used to do the funeral or to help to alleviate any sort of pressure already or stress of that person passing away, they're not going to get their hands on any of these properties or estate or assets until 6 or 12 months down the line. You don't want that whilst you're going through all the grief and also the grieving process. So when you have a will, it just prevents all of this from happening.
I wonder, is it because people think that creating a will is expensive? What's the cost involved in having a will? Because I think that's the basics that anybody can have.
And it's not that good question again. You keep coming up with these great questions. So, and it's not that expensive, not at all, not in the slightest. I mean, it costs a couple of pounds really to set a really good will up. Just a few pounds. And sometimes nowadays there's some charities out there that by solely just making a donation to their charity, they can help you to do a really good solid will. And sometimes it's possible that you can pick up even a pack from the shop. The Smith, exactly. A will pack, and then pretty much just do the will, as long as again all of those bits that I mentioned earlier on,
executors, witnesses,
exactly, are all in there, and it's on the document. It means that it becomes a valid will. So it shouldn't or doesn't have to be expensive, and it's not as expensive as it should you think it is. But please, if you have that apprehension of the fact that, oh, I want to make sure that it's all done properly and the wording is right, you know, the law and everything, and I want to make sure that all my wishes go in there, please get a professional, right? Professionally get it done for you, and especially if you have a complex estate whereby it's not just some money, or it's not just maybe one property, but it's more than that. Then I really recommend that you get a professional will writer or a financial advisor like myself, who can help you to be able to put one into place, just to make sure that again you have that peace of mind.
Amazing. Wow. If you have not already got this in place and you are one of those half people that Edem referred to, 50% of people living in the UK do not have a will, then you've got some homework to do. Or maybe if you live in Africa, America, we don't know what the research is like there. But if you are one of those people, I want to remind you, you've got homework to do. Don't leave this to chance. Plan.
Exactly.
Edem, wills are a big one, but what about trust? We hear about these, estate planning, and sometimes we think that trust is for the rich or people who've got a bit more. It's my misconception again. Can you break it down? What is a trust and why is this important in estate planning?
Yeah, another great one, another great topic under estate planning. Again, these tools are there to help us to be able to ensure that we do the right thing by our loved ones. So another one, a trust, is a legal document whereby the person establishing a trust, in this case called a settler, passes on an asset, but the asset goes through what we call a trustee. Yeah. So the trustee or trustees hold the asset for the benefit of someone or an organization. Now, the way that it works is that the asset, for example, how the trust actually works is, one distinctive, before I go on to the next one, one distinctive difference between a trust and a will is that a will can only come into force when you pass.
Okay.
Whereas a trust can be enforced whilst you're alive.
Amazing.
Yeah. So
do it now.
so this is where the next points I'm going to sort of mention becomes quite salient, in the sense that everything we said about the will, that can only happen when you're no longer here.
Okay.
But with the trust, the asset pass on to the trustees, and the trustees hold the asset. And once it passes on to the trustees, you have no authority, you have no control whatsoever over the asset. It's only the trustees that will have control and will have power over that asset. Even in some cases, you cannot benefit from the asset unless the trustees say so. So really, when you pass on the asset, yes, to the beneficiary, you have relinquished all power and authority and control
to the trustees.
And that's the reason why they are called trustees, because they must be people that you trust.
That's
and
right.
You can rely on, depend on, to ensure that they do according to your wishes. Now, so for example, if you have a child or a beneficiary who has special needs, then to ensure that they benefit from, and they don't have the capacity to be able to make decisions on their own or to manage the asset, a trustee becomes of benefit to ensure that they help to administer the estate or your trust to the benefit of that that child or that individual. Or sometimes as well, for example, if you've got a child who is minor, you can put assets in a trust and then stipulate that they cannot touch the asset until they reach certain age. In this case, when you do the minor, and then we come to it, one of the type of trust, they can only the asset will pass on naturally at the age of 18. In that case, when they are dependent. Sorry, they are independent.
Independent, okay.
Apologies. They are independent. So at that age, 18, automatically, because of you put everything in trust and the type of trust they put in place, everything passes on to the trustees will ensure that it passes on to that child, whether you're alive or not. And then sometimes as well, the trust, unlike a will, helps to be able to reduce inheritance tax. In the UK, it's a whopping 40%.
On your estate.
On your estate.
Oops.
After all the reliefs and allowances, it's 40%. And so a trust helps to be reduced.
What's the allowance? Is it 530?
No, so it depends. So if the first allowance, what we call the new rate band, which is 325,000.
Okay.
And then we have what we call the residency new rate band, which is 175,000. So adding both comes to $500,000.
Okay, so about 500.
Yeah, $500,000 per person. So if you are the couple, each individual has got $500,000 each. So if you combine it, combine the assets, you've got $1 million worth to play with before any sort of 40% plus all of that sort of allowances that you can utilize, which will come to a bit later. And so or if you have a business as well.
Okay.
Yeah, if you have a business, for the business owners, a trust, you can use a trust to ensure that there is the smooth transition or succession or transfer of the business to the people who should take over the business. Very important. So these are some of the ways that you can use a trust to ensure that things are done appropriately. But and the last thing as well is that has come to mind as well, and very important, and that there are certain trusts that you can have to put in place. It doesn't necessarily mean that the child or the individual has to be a certain age or whatever, but within a trust you can put in certain conditions.
Okay.
And unless those conditions are met, it means that the beneficiary cannot benefit from the trust.
Wow.
Whether you're alive or you're gone.
Wow. I like the way that you've really distinctively explained the difference between a will and a trust. Now I'm itching. You've made references to types of trust. Tell me, I want to hear these types. What is the types? I'm sure listeners want to hear as well. What are the types of trust?
Yeah. So for our audience, for example, in the US, I mean, and the reason why I make reference to the come to the UK is that when you go on IG or Facebook, there's a lot of this information out there about using different structures to protect your business and the state and the children, all of that. They've got the irrevocable, revocable, they've got the living trust, and they've got the testimony trust. All of this are sort of akin to US laws and US regime. They are not applicable to the UK. So when you see these things out there, it can be exciting, but it cannot be applied in the UK. Yeah. So just be mindful of such things and when you see out there. But in the UK, there are relatively, let's say, about 4 main sort of trusts that we have that people can benefit well from. The one that's always sort of elementary is what we call the bear trust. Okay. So the bear trust is a type of trust which is put in place to protect an asset or to ensure that the asset is being passed on to a beneficiary only at the age of 18. So until they reach the age of 18, they cannot benefit from that asset.
So only when they become an adult.
Exactly.
Bear trust.
Exactly. Or independent. So at the age of 18, automatically everything. And I think you're probably thinking, oh, wow, that sounds familiar. Junior ISA.
Ooh, yes, Junior ISA, yes.
Junior ISA, the structure is a type of bear trust. So effectively it's a bear trust because the child cannot benefit, you cannot benefit, you cannot access it until the child is 18. Automatically when the child is 18 or even if you're 18, remember that you got a letter from the company or the bank to say that, oh, you got some money. You got something. And then suddenly your parents are like, oh yeah, there's nothing available. Yeah, everything is gone. Oh yes, because of the bear trust arrangement around that money, ring fencing that money. That's the reason why. So that's how bear trust happen. If there's a bear trust, around or being put in place for any asset, it can only be utilized at the age of 18. There's what we call, the next one is what we call discretionary trust. So discretionary trust is quite flexible. It has all sort of benefits to it. It ensures that, again, assets can be passed on to beneficiaries, not necessarily when they are 18, but it can be at any sort of age, really. But the benefit of that is that it has the flexibility in such a way that you can really sort of remove put assets in there at will, and you can change the trustees at any point in time whilst you're alive. So it has that flexibility in there. Hence the word discretionary. So that has a bit more sort of open-ended to it in terms of what you can do and what you can't do with it, what you can put in and what you can put in there. And then we have what we call the interest in possession trust.
Okay.
So interest in possession trust is a type of trust whereby if you put it into place, you as a settler, so you, the person establishing the trust, when you put that trust in place, it means that you can benefit from the trust, i.e. you can have income from the trust.
Okay.
So that from the asset through the trust, they can be paying you or an income from the asset.
So is that why you can actually pass that trust on whilst you're alive?
Exactly.
Right.
Yeah.
I've got a question on this.
Go for it.
I'm thinking, does that mean if you pass that on whilst you're alive, you don't have to pay inheritance tax on it?
No.
Right.
So you don't. That's a
Remind me of the name again.
Interest in possession trust.
Interest in possession.
Yeah.
Okay.
It has to be done really according to the law and for you to really benefit from it. So it cannot just be done anyhow. Because the HMRC can frown on it. In such a way that you've given an asset away, so you don't want longer to benefit from it. And yes, so you are. But if it's the right kind of structured trust in place, it means there's a way that it can pay you income whilst you're alive from the asset. Very important. And even there's and again, problem I think that sounds familiar. Your life insurance, your normal life insurance. There's a terminal illness feature, a cover attached to it. That element, part of it, when it's in a trust, it can be paid out the income pays out the lump sum via a form of interest in possession. Because whilst you're alive and you have any terminal illness, the policy must pay out.
That's right.
And with any life insurance, you can put in a trust in a way. And so when it does put in a trust, it just makes sure that it pays out quite quickly and everything that comes to it. So that's a form of.
So that's the third one.
And then the fourth one is what we call a charitable trust. Charitable trust is a type of trust where basically used for charities. Ensuring that charities can also benefit from the tax-free sort of regime by them having that sort of structure in place. So I mean, there are other sort of trusts in the UK for a mixed trust, accumulation trust, and so forth. But really, the core of it is the major four that I've mentioned,
which is bare trust, discretionary trust, interest possession, and charity.
Charitable trust.
Charitable trust.
That's right.
Amazing. Wow, thank you for breaking that down. Right, Edem. So let's say someone has already got a will in place, but they've had their will 5 years, 10 years ago. How often do you think people need to update their will? Or is it necessary to update your will?
Yeah, absolutely it is. Absolutely it is necessary to update your will in every shape or form. Updating your will should be driven by two things.
Okay.
Number one, it should be driven by what I call life events. And number two, it should be driven by changes in the law. Okay, very important. So life events, I mean, life happens, life evolves. So maybe when you did a will, you are not married. And so it was said if when I pass away, there's go to mom, dad, my siblings, my niece and my nephews. Or maybe you decided that you don't want to get married, but then along the line you found somebody that you want to get married to. That is what we call a life event. So at that point, you may want to perhaps consider your spouse or your civil partner to ensure that they are included. The will is amended accordingly. If or when you do have children, it becomes a life event to you. That means that a major life change has happened. If you, for example, you did a will when you had one property, and now the property has grown to 5, 10. Hey, that's amazing. That's another life event. Or sometimes, sorry. So a client of mine, right, did a will. We just everything was all sorted. And then it's a few years down the line, and he called me, and then apparently there was another child that he was unaware about.
Oh dear.
That
know where this is heading. Okay.
He was unaware about, and sometimes these things can happen. And when it did happen, built relationship, everything turned out to be his child, and it meant that the word had to be amended. So when these changes or unexpected sort of changes happen, please, again, if a beneficiary passes away,
it's a good point there.
If a beneficiary passes away, it means that the validity of the will or your wishes is not as you wanted it to be. So in that case, you have to amend the will to reflect the fact that that person is no longer around, and so somebody else should benefit from it. Or it could be that you become affiliated with an organization that perhaps become dear to you. These things happening. For example, there's a story, and this wasn't a client, but a story of I heard that this individual was well and everything, but then life happens, and he had a terminal illness, and so terminal illness fought his way through, and then recovered through the help of an organization, a charity. And so that charity became almost like something that was quite dear to his heart because of the support that they've offered him through the whole journey to recovery, because he thought that he wouldn't survive, but it was just the sheer support of the charity. Then he had to amend the will because he voluntarily, willingly wanted to amend the will to include a charity that, if anything,
to give other people the opportunity
to benefit from the support they had. So when these life event happens, please amend, review the will, and even if it doesn't have this life event as it happened, maybe just always go and check to ensure that everything is still really there. But now, every now and then, if the law changes and you hear something on the news or you read something elsewhere, you want to make sure that it's according to your wishes in the will. Sometimes you may discover a new knowledge about your estate, about your will, and maybe your trust, which will come to later on. The fact that you need to make sure that if anything happens to me, all my estate or my assets should be preserved within the bloodline. Okay.
Interesting.
If you find about this knowledge about something new that you thought, let me see if it's in the will, let me see if the trust is part of that, or there is the need you need to do an asset preservation trust. I mean, or God forbid, if there's a divorce or separation or whatever, all of these things, when it does happen, make sure that the will is updated.
It's interesting you mentioned divorce. There was a case, I think it was in the UK news actually, where someone passed on and had forgotten to make the changes to the will, and this person's insurance named the ex-husband instead of the current husband, and that was not pleasant.
It wouldn't be. It wouldn't be. But there we go. When these mistakes happen,
it's there for us to learn from.
It's there for us to learn from.
Of course,
And the last one I want to make as well is that, please, mind you, there is no emotions that is attached to the will or to the document that expresses your will. that expresses your wishes. So, and in order to ensure that it's done according to your wishes and not according to any emotional satisfaction, because in the case I just mentioned right now, I mean, when you think about it, you think that, oh, it's not fair. All emotions will get into place and all of that. But when the document is there,
the document speaks.
The document speaks. It has no emotion attached. The only emotion attached to it is the wishes of the testator.
Yeah.
To make sure that your wishes are expressed accordingly.
Great. If you have found these videos really helpful, I'd like to remind you, like it, share it with someone who might need it, and don't forget to subscribe to B3 Inspire. So yeah, keep your beneficiaries current. So Edem, I know when you are planning, do this estate planning, earlier on I think you mentioned power of attorney.
Yes.
Okay, so that's about decision making when you are alive, but you are incapacitated.
Correct.
Can you break this down for us? What does it really mean, or why is this relevant in estate planning?
Yeah. So again, life happens, life evolves, and one of the more the key mistakes I see people make when it comes to estate planning is not planning for incapacity. So these things nobody again expect it to happen, but again it's if it happens. I mean, death will happen, but incapacity might not happen. But if it does happen, we should be prepared. And that's what really power of attorney is all about. Power of attorney ensures that if you lose capacity, you have someone available, or in this case, that person will be called the attorney. The attorney will be available to help you to make decisions whilst you are alive, to your benefit. Okay. And just like the trustee to the trust, attorney is for power of attorney, and to ensure that somebody again that you can rely on, somebody you know will do right by you, do right by your state, do right by your children, do right by your guardians, do right by the people and the things that you love. So there are mainly three, well, mainly two, but the third one we'll come to later. So in the UK, I mean, there used to be what we call enduring power of attorney, right? I mean, if you still have them, yeah, they are still they are still there. You can use them, but now the enduring power of attorney have been replaced by two main types of tools. The first one is the lasting power of attorney for health. Okay, and that's LPA, isn't it?
Yeah. Usually, I've heard that quite often. Yeah.
So I've been replaced by the lasting power of attorney, but the lasting power of attorney is broken down to two, which is the lasting power of attorney for health. So that really is for in case you need somebody to be able to make right health decisions on your behalf, in case you don't have capacity to be able to make that decision, to sign things on your behalf according to your wishes or whatever. And that's the reason why, again, you need to be able to be in a place whereby you can communicate your wishes whilst you're alive to the people that, or to the people that you trust, that you know will do the right thing by you, for if the eventuality happens or when death happens. So that is the lasting power of attorney for for health. And then we've got the lasting power of attorney for finance and property. So that is to help you so that somebody can nominate someone as an attorney to make decisions on your behalf concerning your finances and concerning your properties, and concerning, for example, if you have to go to a care home and you have lost capacity and you have to take a care home, or for example, some people have got a wish that they do not never want to go to any care home. They want to be taken care of in their own home. And you have the wishes that never take the care home, but make sure that I'm looked after and I die in my own home. Again, it's your wish. Make sure it's clear. But that all of that, if you lose capacity, can be arranged whilst you're alive, and you haven't got the capacity, whether mentally, physically, whatever, has to be done via the lasting power of attorney for finance property. I mean, you can have one, or you can have both.
Okay.
Yeah. So because either can happen. You may need to make a decision about your health. You need to make a decision about your finances, your property. You need to decision about both if you don't have the capacity, because some people may not have the capacity to be able to, for example, maybe write or so whatever it is. But then if that happens, they have the ability to speak. And again, you can also stipulate the extent of the powers of the attorney. Okay. And again, the last part of attorney as well is so flexible that you, at any point in time, you can replace the attorney. Yeah. So maybe it could be temporal or it could be lasting, because again, it's until you gain capacity, or if you don't have gain capacity any longer for as long as possible, there is that person in place who can help you make that decision whilst you're alive.
You mentioned the third one.
Yes. So there's a third one, which we called the advance directive.
Okay.
So the advance directive, especially more of those who work in the health services, NHS, the NHS people can really identify with this. So for example, there is that aspect of the lasting power of attorney to make sort of health decision for you, but there's also that aspect, for example, which is very in cases kind of end of life decisions, where they have to terminal, and when it comes to situations where they may have to maybe switch something off or keep something on. So again, you can sort of
resuscitation.
exactly you can stipulate that and express that in the advance directive to ensure that if any of this is to happen, you've got that document which has got no emotions attached to it, but only your wishes can be done for you.
And in terms of having LPA, can you have it as part of your will and have it as part of your trust?
Exactly. So you can have you can have a will, you can have a trust, and you can have an LPA. Lasting power of attorney, all run alongside each other. But again, when you do, sometimes the will and the trust, there's something we call will trust, that could be done together. But the lasting power of attorney is always a separate document on its own, because of the nature and the structure and what is used for, and its benefits. So they you can have all of them run alongside each other, because they all serve really different purposes. But it all depends on what you want to achieve. Again, the complexity of your state and what you want to make happen.
Excellent. Wow. If you have found this video really insightful, I'd like to remind you, share it with somebody who needs to hear this, like it, comment on maybe an aspect that you would like further clarification on. Any questions you may have, put it in the comment below. Right. Thank you. With the LPA, is there a case of doing it with a financial expert, or is there an easier way people can access this tool?
Yeah, so with the lasting power of attorney, there's two ways it can be done. It can be what we call DIY, do yourself, or it can be done via a professional will writer or estate planner. If you want to do yourself, I mean, you can go to the .gov website and then just follow the link, quite sort of systematic reading and step by step, follow the process. Then it will direct you to the documents that you need to complete. And once completing it, and make sure it's signed accordingly, and then witness. And then once it's done, you have to register through what we call the Office of Public Guardian. So the Office of Public Guardian, there's a fee that you have to pay to register it. Again, it's quite straightforward, but if you're not confident, you're not sure, don't want to get involved, with all of sort of the technicality that it comes with it, by all means, let the professionals help you to put one in place again for that peace of mind, making sure that ensuring that you got the confidence that it's all done for you in the right manner. So yeah, those are the two ways it can be done. Just to ensure that you have that tool and that legal document and valid document in place to protect yourself and to protect the things that are dear to your heart.
Excellent. If you would like to do it DIY, do it yourself, there's a link below this video that you can click and do that. Edem, earlier on in our series of the video, you mentioned about intergenerational wealth, and we touched on entrepreneurship. I'm just wondering if suppose someone has a family business or a significant family wealth, can you give them any tips on succession planning?
Yeah, so when it comes to succession planning, when it comes to business, there are ways to ensure that it passes on in the right manner. So please, and another mistake as well that I come across is people assuming that when they do pass away, they've got family business or they've got business, automatically will just pass on naturally to the right person, or maybe the person that has got the ability and the capability to run the business. It doesn't necessarily happen that way. So assumption is one of the key mistakes that you should avoid when it comes to estate planning. Again, the document that you put into place, the agreement that you put into place, the tools are there so that there are no emotions attached to it, but they are done according to your wishes.
Yeah.
So you can basically, for a family business, there's options available. There's something we call the cross option agreement. The cross option agreement basically means that you do have an agreement in place whereby immediately you pass away, according to the deeds of the company, being signed by the directors, they automatically it's passed on to the directors of the business, or if it's a partnership, it's passed on to the partner that you stipulated in there. The other way is also by share agreement. So whereby again you allocate shares in the business, and with the business you allocate certain rights to the shares. So some people or some family members or relatives or family members may be more capable than the others. Okay, some of you might just want them to be dormant shareholders. Others want them to have shares with active role running the company. Again, all of these has to be stipulated in there. But you can also have a trust as well. A trust in place, which also will ensure that if anything happens, I mean, in case of the trust, all of the business and the structure of the business points to the trust, and within that trust up there are the beneficiaries of that trust, and it stipulates exactly who the beneficiaries are and how they benefit from the business. So again, the trust becomes an entity on its own, but within that entity there are different roles that are being stipulated in there to ensure that the business run with continuity in your absence. So think about all these sort of the wealthy companies and around the world, with the Rothschild and so all of they have been able to pass things on by having the right sort of structure or trust structure in place to ensure that things pass on accordingly without any issues at all. And succession planning, intergenerational wealth is by using these tools ensures that nothing or the business doesn't go down, and the business is carried on in the right manner. And I sometimes as well, it could also mean, I mean, by you putting the structure into place, that you have maybe a quote unquote a sitter. That's why I call it a sitter, who is not necessarily a family member but has got the capacity to be able to run the business until such a time when he has trained maybe the heir of the business to a capacity where he or she is able to take over, and then things will just pass on. there are various ways to making sure that things stay within the company, but it needs to be written down. Remember, it needs to be stipulated, not just mentioned or just articulated before it can be upheld.
Excellent. Wow. Thank you so much for breaking that right down. This has been a comprehensive session on estate planning. Wow. Thank you for sharing all those great nuggets and takeaways. Just a quick recap of our takeaway. So everyone should at least have a will and power of attorney for finances and for health. And of course, you can also have the trust and be very efficient in your planning so that the right things go to the right people when you are no longer here. Thank you. Any golden nuggets that you want to add to this?
Yeah, absolutely. So when it comes to estate planning, really it's not really about end of life. It's really about the legacy that you want to create.
I love that.
When you are no longer here. So how do you want to be remembered if you are no longer here? There is a financial colleague of mine, and her husband passed away, right? And then she said that I said, I miss my husband so much, but one of the things that I really did not have to miss him about is the fact that he prepared before he left. So because of that, she's not even, it's not something that she's bothered about. She has to bother about just because he prepared. So
right.
I've not missed him because he didn't prepare.
No.
But I've missed him for all the right reasons. I'm sure you also want to be missed for all the right reasons. So much so that you prepared. You prepared for your loved ones. You prepared for your the love, the company. You prepared for the estate. You prepared for the charity, for the church. You prepared for that organization before you left. That you creating that memory in such a way that when you're no longer here, the people that are really dear to your heart, they can be taken care of, and not wondering if he ever lived right or not. So don't leave that question mark in their mind just because of a document. Which is it because of the cost? Maybe not, because you did not bother. I'm sure they don't remember you or know you as somebody who is careless. So ensure that document is in place. Is it because they feel that you are so much emotionally driven that you have taken care of so much of them, and now you just want to leave them to do whatever you want to do? No, I'm sure you don't want that to happen. So let that document be in place and really live well.
Thank you. I really love this. What legacy do you want to leave? If you have found this video really helpful, I want to remind you to subscribe to B3Inspire, turn your notification on so you don't miss any other videos. Wow, we are on to our next episode.
Yeah.
Episode 10. And we are talking all about inheritance tax. How to plan effectively and efficiently. You don't want to miss that. And I'd like to remind you, in all you do, build your foundation, believe in your potential, and become unstoppable. See you in the next video.